Based on the procedural posture you've described, it sounds like Fredrickson may be conflating what he hopes will happen with what has actually happened procedurally. There are two completely separate cases. One, the criminal harassment case. Two, the federal civil lawsuit. Each has its own procedural posture. Criminal case. If the criminal case is currently in competency proceedings, then that issue generally takes priority before the case moves toward trial. Until the competency question is resolved, the court's focus is typically on whether the defendant can proceed, not on litigating the merits of the harassment charge. Federal civil case. For the federal lawsuit, you describe the case as still being in the court's initial screening or review stage, with an amended complaint recently filed, no order directing service, no service on defendants, and therefore no appearances by defendants. If that is the current docket status, then procedurally, the judge is still deciding whether the amended complaint satisfies the applicable pleading requirements. Defendants ordinarily have no obligation to respond until they are properly served or otherwise ordered to respond. And, until service occurs, defendants are generally not required to file answers or begin litigating the merits. Whether a particular defendant already has counsel is a separate matter. Government entities, such as counties and cities, commonly have legal counsel available, either in-house or through retained attorneys. But if no service has occurred, there is generally no procedural obligation to appear in that specific lawsuit. Time to lawyer up. Fredrickson's statement, open quote, "It is time to lawyer up. Two of the defendants are going to blow the case." Close quote, appears to be a prediction or opinion. If, as you describe, the case has not yet passed judicial screening and no defendant has been served, then procedurally, there may not yet be anything requiring those defendants to respond in court. The cart before the horse. The phrase is apt in the sense that federal litigation follows a sequence. 1. Complaint filed. 2. Court reviews the complaint, where applicable. 3. If the complaint is allowed to proceed, service is authorized. 4. Defendants are served. 5. Defendants respond, answer, or Rule 12 motion. 6. Discovery and later stages follow. If the case is still at Step 2, then discussion of defendants blowing the case is premature because the court has not yet determined that the amended complaint will proceed. Repeated amendments. You also mentioned that Fredrickson filed another amended complaint. Generally speaking, when a new amended complaint is filed, the court reviews that operative complaint. An amended complaint supersedes the earlier version, and the judge evaluates the current pleading before determining whether the case may proceed. Overall, based solely on the procedural posture you've described, the criminal case is presently focused on the competency issue. The federal case is presently focused on judicial review of the amended complaint, and neither case appears to have reached the stage where the substantive merits are being litigated before a fact finder. So, if those procedural facts are accurate, statements suggesting that defendants urgently need to lawyer up or that the case is about to be lost would be describing a stage of litigation that has not yet been reached. Whether the civil case advances at all depends first on the district judge's review of the amended complaint and any subsequent order authorizing service.